I'm Carrie Needvelt Thomas, President and CEO of the Better Business Bureau, serving Minnesota and North Dakota. Thank you so much for joining us today for the Minnesota New Privacy Law and What Your Business Needs to Know session, brought to you by the Better Business Bureau and the Minnesota Attorney General's Office. At BBB, we're committed to helping businesses and nonprofits build trust with their consumers and communities. Part of that is being informed about changes in laws and regulations that impact how we all operate. Today's topic is an important one. The Minnesota Consumer Privacy Act takes effect at the end of this month on July 31, and it will bring significant changes for any organization that collects consumer data, from updating privacy notices to managing new consumer rights and data inventories. We are so pleased to partner with the Minnesota Attorney General's Office to bring you this free practical session. Our goal is to help you understand what this new law means for you and provide the tools you need to stay compliant, avoid penalties, and continue to build trust with those you serve. Thank you again for being here. And with that, I'll turn it over to our presenters to get us started. Please welcome attorneys Caitlin Micko and Noah Llewellyn. Noah Llewellyn is an Assistant Attorney General in the Office of the Minnesota Attorney General's Consumer Protection Division. He has served the office for over 9 years in roles ranging from criminal prosecution to state agency civil defense. Noah's consumer protection efforts often include providing education to Minnesota consumers and businesses on the implementation and enforcement of Minnesota laws. Caitlin Micko is an Assistant Attorney General in the Office of the Minnesota Attorney General's Consumer Protection Division. She has served the office for over 10 years and worked primarily on consumer protection matters. Caitlin's current focus is on privacy and data security. So welcome.
Thank you so much. Thank you to everyone at the BBB, and thank you, Carrie, for the warm welcome. We are glad for your interest and the BBB's interest in the Minnesota Consumer Data Privacy Act and the AG's enforcement of the new law. So we will go ahead and get started, but first, just the quick disclaimer that our presentation today reflects our own opinions. They are not necessarily those of the office and should not be construed as legal advice. Our presentation today will by no means be exhaustive, report on all requirements of the law. This really is a major piece of legislation with many component parts. Cannot possibly cover it in the time allotted today, but this hopefully will serve as a starting point. Our goal for today is to introduce the law and hit on some high points to those that are unfamiliar with it. We want to highlight where Minnesota law is different from other state privacy laws, and we want to give some insight into what is ahead in terms of enforcement. The presentation will have 2 parts. First, we'll talk about the legislative history, the requirements of the law, including new consumer rights, what businesses are required to do to comply, and how Minnesota is unique. And then we will also discuss the Minnesota Attorney General's Office. We'll talk about our mission, the Consumer Protection Division, where the privacy work will be housed, and our early plans for enforcement. So just a little bit about how this law came to be. The law was first introduced in 2019 and it was sponsored by Minnesota State Representative Steve Elkins. I've spent some time with Representative Elkins talking about this bill, and I think it's helpful to frame and to know that he took up this bill after a local Microsoft lobbyist brought him a draft of the Washington Privacy Act and encouraged him to carry a similar bill in Minnesota. The Washington Privacy Act never actually passed, but it nevertheless became the framework for many state comprehensive privacy laws. And Representative Elkins has a lot of experience in this area. He spent 25 years in data and information architecture. So he took the privacy law and worked the framework from Washington and spent the next 5 years working to improve upon that, including by hearing from dozens, if not hundreds, of stakeholders to gather their input on the bill. It was passed last year, signed by the governor, and is set to take effect now in just a few days on July 31st. This makes Minnesota the 18th state to enact a comprehensive privacy law. One of the central pieces of the law is that it will afford Minnesotans more control over whether and how their personal data is handled and managed. It does this by creating new consumer rights. So under the Act, consumers will now have the right to confirm whether or not a controller is processing personal data about the consumer, as well as the categories of personal data being processed. So a consumer might ask and be entitled to know, are you collecting information about me? What sort of information are you collecting? Consumers also have the right to correct inaccurate data about them, as well as the right to ask that data be deleted. They can request that a business delete data that has been collected directly from them or otherwise about them. And they have the right to obtain personal data in a portable and readily usable format. In addition to those rights, consumers can now opt out of certain ways that data is used. For example, a consumer can opt out of the processing of personal data for the purpose of targeted advertising. A consumer can say, I don't want you to use personal data about me to send me targeted ads, and the controller needs to honor that request. Consumers can also opt out of the sale of personal data, as well as profiling done in furtherance of automated decision making that produces legal or similarly significant effects. And the way we're thinking about this is a consumer can now say, I don't want AI to decide whether or not I qualify for an apartment or a job or a certain financial product. And importantly, and we will talk a little bit more about this later as well, because it's unique to Minnesota, but if a consumer is profiled, the consumer will have the right to question the results of that profiling decision. And they are entitled to know, the background, how that decision was made. If it was inaccurate, they can ask for data to be corrected and have the profiling decision reevaluated. So an important question as we dig into the consumer rights is what entities and businesses will have to comply with these right requests along with other provisions and obligations in the law. Minnesota follows the threshold framework seen in other states. So an entity that collects data of 100,000 Minnesota residents or more will be subject to the act, as well as entities that derive over 25% of their gross revenue from the sale of personal data and also process personal data of 25,000 consumers or more. Those entities will also be subject to the act. And a few points here, the way that the threshold is really set up, it could capture some very small businesses if they are collecting a lot of information about Minnesota residents. So just because the entity is small, you still need to think about what kind of personal data you're collecting and does it meet the threshold. It's also important to remember that consumer is not the same as customer. So even if you have less than 100,000 customers, if you maintain data and process data about 100,000 Minnesota residents or more, you will be subject to the act. So, also want to point out that nonprofits are subject to the act, and we'll talk a little bit more about that, as well as controllers or processors acting as technology providers are subject to the law. And now I will turn it to Noah to talk a little bit more about the scope.
So the scope of the Minnesota Consumer Data Practices Act is separated into two different exclusions or exemptions, categorically excluding some entities and some data. Some previous privacy laws in other states have done one or the other, but the reason that Minnesota adopted kind of this hybrid approach is that some early comprehensive data privacy laws that wholesale exempted entities that were subject to highly regulated laws like the GLBA, which is the Gramm-Leach-Bliley Act, or HIPAA, which is the Health Insurance Portability and Accountability Act. The entire business was outside the scope of the privacy law, but that became problematic when entities were claiming the exemption even in situations weren't intended. So the example that we have here is that car dealerships that were subject to GLBA for their financing arms were claiming that their entire business was exempt under the law, including like for sales or just advertising. So now states are starting to favor data level exemptions, which is to say data that's already protected by covered laws. They're not going to be subject to the MCDPA, but other collected data will be. So we're going to go over kind of some of the data level exclusions. This is not going to be an exhaustive list. You're going to hear Caitlin and me to say this several times throughout the presentation. The law really is quite large and long, and I strongly encourage you to take a look at the text yourself, or have an attorney do it for you. But at the end of the day, we've highlighted what we think are some of the more relevant or more interesting to talk about examples. So under entity exclusions, there are still some entity level exclusions in Minnesota, government entities, Indian tribes, basically sovereign nations, right? State or federally chartered banks or credit unions, these are highly regulated businesses where the federal government has kind of filled the field. Insurance companies, very similar, highly regulated, generally by state governments, and small businesses. So we talked earlier about how you can be a quite small business and still collect information on 100,000 Minnesota residents. But if you meet the definition of a small business pursuant to the SBA, that's the Small Business Administration, then you are not going to be subject to this law, with one exception, which is that you cannot sell sensitive data without consumers' consent. We're going to go more into what sensitive data is and what that includes later, but know that if you're sufficiently small, you actually will not be subject to this law. Some data level exclusions that we're going to talk about are the Gramm-Leach-Bliley Act. That's largely a financial data. HIPAA, you probably know this most as personal health information, or PHI, mostly handled by healthcare entities. The Driver's Privacy Protection Act, which is generally information collected or gleaned from driver's licenses. The Fair Credit Reporting Act, information submitted to you by job applicants specifically for the purpose of employing that person or looking at their resume for hiring, and payment processing data. There are others that we haven't really highlighted on this slide that are important to certain industries, like FERPA, that's education data held by educational institutions, or airline data, because airlines are generally very highly regulated by the federal government. So, how do you know what your obligations are once you think you might be subject to this law? There are obligations split between controllers and processors under the MDCPA. The distinction in the law is intended to lay out and define obligations and duties between the companies who have these third-party arrangements for dealing with the data. So, like if you're a controller, but you collect a bunch of data, then you might hire a processor, a third party, to handle that data for you or make decisions about what to do with the data or process it. We're going to come back to making decisions about the data, but you don't have to have a processor if you're a controller. It could well be that you process your own data, but there is no processor without a controller. So who are the controllers? Controllers are companies or entities making the big decisions about what to do with the data. They're generally speaking going to be the bigger name in this relationship in a controller processor. They tell others what to do with the data they collect. And maybe most importantly for this conversation, they're the ones holding the bag and probably the ones who are going to be responsible if there are issues in complying with the law. Who are processors? Generally speaking, these are entities that are operating behind the scenes. They're managing structural obligations of controllers. They're manipulating data, holding data, making data available to the controllers upon request. The important distinction here is that processors don't get to determine the purpose or means for processing the data. If you start doing that, you start to look like a controller, and then you have all this whole other set of obligations that may come along under the law. You can have obligations of both entities. Like we said before, you can be a controller who processes their own data, in which case you would be both a controller and a processor. I have liked to say that you might think of controllers and processors like users and computers, respectively. The controller is telling the processor what to do with the data, and the processor does it. There can be a lot of background tasks going on with the processor, inventorying data, processing it, and so forth. But at the end of the day, the controller directs the process what to do. So determining whether a person, I'm going to quote from the act here because it really does hit the point of who is a processor and who's a controller. Determining whether a person is acting as a controller or a processor is a fact-based determination that depends on the context in which personal data are to be processed. A person that is not limited in the person's processing of personal data or that fails to adhere to a controller's instructions is a controller. So it's just good to be careful of the distinction that comes between those and make sure that you understand the relationship with your data and how you're handling it. So we're going to talk about, before we go much further, we should talk about what personal and sensitive data actually is under the Act. Personal data is data that can be reasonably used to figure out who you are, essentially. It doesn't include publicly available information or de-identified data. The MCPA defines what it means for data to be made publicly available. Information is, so it's not necessarily a common sense definition of what publicly available is. Information that is publicly available is data that is lawfully made available from federal, state, or local government records or widely distributed media, or data which a controller has a reasonable basis to believe has lawfully been made available to the general public. So the important distinction here, right, is you might think something is public data because you can go to a third-party clearinghouse and purchase that data, and that seems like it could be public data. But it might not be. And so you have to, just because it's for sale to the public does not mean that it is in fact public data under that definition. And so you would still be dealing with personal data under that. De-identified data is a little different. You have to take personal data as it comes to you, right? So if you find personal data, there's nothing that you can really do about it other than that now you know it's personal data, and you have to deal with it in that way. And I'm setting it up like that because de-identified data is a little different. While controllers have to take publicly available data as it is, controllers can functionally create or receive de-identified data. You can't make publicly available data, right? But you can make de-identified data because de-identified data is data that can't be reasonably used to infer information about or otherwise be linked to an identified person or device linked to an identified or identifiable natural person, as long as you take a couple of steps that are laid out in the law, which I would encourage you to read further about if you're interested in de-identifying your data. But for the purposes of our conversation today, I'll kind of pass over. Sensitive data is a form of personal data. So I'll just pause there. If it's not personal data, it's not sensitive data. So just refer to the previous definition of personal data if you're worried whether or not you're dealing with sensitive data. So by definition, for example, de-identified data is not going to be sensitive data because it is explicitly not personal data. Sensitive data is a subset of personal data that includes private information such as race, ethnicity, religious beliefs, mental or physical health conditions or diagnosis, sexual orientation, citizenship or immigration status, or specific geographic location. It's also personal data of a known child. Sensitive data is going to be subject to heightened protections. We've already discussed one of those heightened protections. No controller, including small businesses otherwise exempted from the law, can sell sensitive data without the consumer's express consent. Controllers who are not small businesses can't even process sensitive data without obtaining consumer consent. And when I say consumer consent here, and whenever I'm talking about a consumer in the context of the law, it's important to understand that the law allows a consumer to operate and exercise their rights or a consumer's designated representative. And so when I say consumer, it could be a minor's parent, for example, or a legal guardian or another representative named pursuant to the act. All right, so let's talk a little bit more about some controller obligations. These are the big obligations that are going to be that most businesses will be subject to. Again, there are many obligations that we are not highlighting here and would encourage you to look through the act. But these obligations include both structural obligations and content-driven obligations, which is to say the law has provisions that require controllers to adopt certain mechanisms or internal protocols, structural, and to treat certain collected data in specific ways. And that's what I mean by content-driven. I'm going to give the same caveat again. The statute's large. We're not going to go through all of them. We've selected some. We've got 9 here up on the screen that we think are probably the most interesting to talk about right now, but would encourage you to take a look at others. So I'm going to start with consent. A number of provisions in the MCPA require consumers' consent. Consent has to be freely given. It has to be specific, and it has to be informed, and it has to be unambiguous. Those all read together require a heightened level of consent, more so than maybe you've been dealing with in the past. Acceptance of general or broad terms of use or a similar document that contains descriptions of personal data processing along with other unrelated information does not constitute consent. So if you have a data privacy policy that's buried in terms of service or other use, it may not be compliant with this. Acceptance is not, and consent does not include closing a piece of content. So what does that mean? What does that look like? If you've ever been to a website that says, "Hey, we're going to use your cookies," is that okay with you? And it has a yes, no, or opt out or whatever button, and the consumer just clicks X to get out of it. That is not consent under this law, and so they have not given you consent to collect cookies by exiting the option. Um, there's also dark patterns that are unlawful under this act. A dark pattern is defined and means a user interface that's designed or manipulated with the substantial effect of subverting or impairing user autonomy. Maybe that means a display with a visible accept all cookies button and a reject all cookies button that only appears if you hover over it, or if it's like blacked out, or has an oversized accept button and a miniature reject button. So that's going to be another fact-intensive determination. But the whole point here is to show that consent is a defined term that is kind of interplays with a lot of different aspects of the law. And the obligation I'm really trying to highlight here is that controllers both need to have a method of obtaining that consent if they intend to process personal data in certain ways or process sensitive data. And controllers have to provide a mechanism where the consumer can revoke that consent that they previously gave. And the method of revocation has to be as easy as the way it was obtained. So I think that partially answers that question. Can consent be revoked verbally is one of the questions in the chat. If you obtained consent verbally to begin with, then I think the answer is that it has to be as easy as you obtain the consent. We'll come back to enforcement about attorney fees and treble damages. I think one of the important things to recognize here before we come back about what enforcement looks like is that there's no private right of action. And so you're going to be dealing with the Attorney General's office for enforcement, and we'll probably address more of that later. All right, so I'm going to go ahead and briefly touch on data minimization. There's a number of provisions in the law that put limits on how much personal data can be kept or processed depending on the use of that data. And there's a concept that reappears throughout the law about how you really shouldn't be retaining any more information than is necessary for you to process or keep to fulfill or to complete the goals of processing that data that you disclose to the consumer. I'm not going to harp too much on this, but I think it just shows a reflection of the law's overarching purpose of really kind of enshrining into statute best business practices of why you really you shouldn't have more data than you know what to do with, right? Is kind of the concept there. Transparency, the law requires disclosures to consumers about what controllers want their data for and what they're going to do with the data. Hand in hand with that is the law's structural obligation of having a privacy notice. We're going to come back to privacy notices later. There's a data inventory requirement that you have to maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data. And that includes maintaining an inventory of the data that has to be managed to exercise these responsibilities. This is important, particularly in the context of enforcement, because if the Attorney General's office comes and wants to know what data you're holding, you have to assume that one of the things we're going to ask for is an inventory of the data that you are holding, and if you do not have it, that will be a violation of the law. So hand in hand with the data inventory obligation, as I just said, there's an obligation to maintain administrative, technical, and physical data security processes. You probably, as any entity that controls data, have some of these. I think it's just important to recognize that there's now a statutory requirement to protect this data in the MCPA, and I would encourage you to take a look at it. I'm going to skip ahead a little here, go straight down from protect data to data protection assessments. These are data privacy and protection assessments under the law, or DPPAs. These are reports that a controller has to have on file for activities including processing of personal data for targeted advertising, sale of data, processing of sensitive data, processing involving heightened risk of harm to consumers, and certain processing involving profiling, which is automated decision-making impacting a consumer's legal rights or other similar serious rights. So I mentioned that controllers must have a DPPA on file. And again, that's because During an enforcement action or an investigation, the Attorney General's office is specifically empowered by the law to seek and obtain a DPPA under our authority. So these are assessments that are specifically required for companies to undergo and to have somebody take a look at your own security practices. I'm just going to briefly kind of talk about the universal opt-out mechanism. There's a push among a number of states, specifically Colorado, but to enshrine in statute what's a signal of and this can be conceptualized as like a browser extension that might, for every page they visit, have an automated signal that sends to your entity, this consumer would like to opt out of targeted advertising. The law goes into some detail about what such a signal would include. It also says that if you're compliant with another state's universal opt-out mechanism requirements, then you're going to be compliant with Minnesota's. But it would be good to kind of familiarize yourself of what a universal opt-out mechanism looks like and that your website is accepting them and you know what to do with them when you get them. There's two other things on this slide that I'll touch very, very briefly before turning it back over. But there's to processor obligations, but we want to be able to respond to rights requests. Obviously, if consumers have new rights, you are going to be responsible for actually listening to them and respecting those rights. You need to have some way of dealing with them. So that's going to be both content driven because you need to know what the rights are, and procedural in the sense that you're going to have a portal or email address and person in charge of fielding those requests. There are certain contract requirements placed in the MCDPA about what contracts between controllers and processors must have. And I'm highlighting that only to say that if you do intend to kind of outsource a lot of these procedural like steps like inventorying and so forth and taking care of your data, it's important to know that the MCDPA has specific contract requirements in it that must be included in the contract with your processor. All right, a lot of time in that slide, but we're going to move forward to processor obligations. So these are a lot shorter, but it's because the processor's ability and decision making is so limited under the MCDPA. Again, if it weren't limited, if they were doing whatever they wanted with the data, then they'd be a controller. And so then all of those previous obligations that we talked about would start to apply to them. But generally speaking, processors are obligated to adhere to controller instructions. They have to enable the controller to respond to rights requests. They have to provide information for those DPPAs that we talked about. They have to adopt security safeguards, and they have to comply with those contract requirements that are in the law.
Thanks, Noah. All right, so we wanted to spend a little bit of time making sure we touch on what is unique about Minnesota's law. For some of you, you might be familiar and already working to comply with other state comprehensive privacy laws, and so we want to point out what is unique and interesting about Minnesota's law. With regard to scope, we've touched on the small business exception. Minnesota is one of the few states that takes this approach together with Texas and Nebraska. But just a reminder again that even though small businesses are exempt, they still cannot sell sensitive data without consumers' prior consent. Minnesota is also unique in requiring nonprofits to comply with the law. In terms of definitions, the definition of specific geolocation is unique to Minnesota. Representative Elkins has spent quite a bit of time talking in public about this. He determined through his work with stakeholders and I think from his own experience as well, that the best way to define geolocation data is in terms of longitude and latitude rather than how you see it in other statutes, which is usually defined in terms of feet. And so this is something to take a look at. The way we see it is not materially that much more or less protective, but just measured differently. When it comes to consumer rights, what probably sets Minnesota apart the most is that consumers have the unique right to question profiling decisions, as we mentioned at the top. So under the law, if a consumer's personal data is profiled in furtherance of decisions that produce legal or similarly significant effects, that consumer has the right to be informed of the reason that the profiling resulted in that decision and what actions would have secured a different decision. They can review the data that was used in the profiling, and they can ask for inaccurate data to be corrected and the decision to be reevaluated with the corrected data. This is quite a significant advancement from other privacy laws and will give consumers a true check on what could otherwise be problematic or harmful profiling decisions. Another consumer right that's worth calling out is the consumers in Minnesota can now request information about where information was disclosed, or otherwise known as third-party lists. And so this does not just include categories of third parties, but the specific entities to whom received this consumer's data. And if that information is not available with regard to that specific person, then the entity needs to provide the list of third parties that received any individual's personal data. And this really allows consumers to follow their data downstream and understand who it went to. There are just a few states that have this similar requirement. Oregon, I believe, was the first. Minnesota followed, and I believe Connecticut has now passed a similar requirement.
Briefly, we have a question in the chat whether or not we'll have access to the slides. I don't know that you'll have access to the slides, but I think we've already put in the chat privacymn.com is the new website. And a lot of the information that we're talking about here, at least in its bullet point form, there is a link on that website for information for businesses that you should feel free to check out that we've made available prior to the enactment.
Thanks, Noah. With regard to controller obligations, just again want to call out a couple that are unique to Minnesota. Minnesota's law requires controllers to document the policies and procedures that have been adopted to comply with the new law. And it's the first state that requires the appointment of the chief privacy officer, or the way it's written in the law, you have to provide the name and contact information for the individual with primary responsibility for directing the policies and procedures that have been implemented to comply. We're also the first state to require controllers to maintain a data inventory that Noah mentioned. This is similar to a requirement of the GDPR, so it may not be totally brand new to all businesses, but it is a good example of a best practice for addressing compliance requirements. So companies can know and should know what are their data sources, types, storage locations, access rate, deletion policies, that sort of thing. It's not uncommon for state privacy laws to prohibit controllers from processing personal data in violation of anti-discrimination laws, but you'll notice that Minnesota's law is even more explicit with this provision. And then relating to the privacy notice, Noah talked about the requirement that notice must be accessible, clear, meaningful. Minnesota requires privacy notices to include description of the retention policies for personal data and the date the notice was last updated. But the law also does give a little break and explicitly says that a controller is not required to have a separate Minnesota section as long as the general notice contains all of the required information. Touch on the cure period. There is a cure period built into the law, which will serve as sort of a cushion for those who are working to come into compliance. Some states have discretionary cure periods. Minnesota law, cure period is mandatory. The cure period essentially requires the AGO to issue a warning letter that details the violation that we have observed and permit 30 days for the entity to come into compliance before we can initiate an enforcement action. This component of the law expires in 6 months, January 31st of next year. And at that point, we will no longer be required to engage in the letter writing process and can move straight to enforcement. But I just want to mention that the cure period is very much in line with how we typically handle our investigations. It's not uncommon for our work to first engage with the company, identify what we see as a potential problem, and try to sort that out before official enforcement action. So with that, we'll spend some time talking about the Minnesota Attorney General's office, and I'll turn it back to Noah.
Yeah, we did just finish off by saying there's a cure period, and then we went straight into enforcement. I just want to echo what Caitlin said, which is that, we're here and we're engaging with the business community specifically because we are interested in obtaining compliance, and education is the best way to do that. Not enforcement, right? And so we are hoping to work with everybody even well beyond the safe harbor period when it expires in January. And we hope that you'll reach out if you have questions, um, sp- particularly if you're curious about whether or not you're complying appropriately with the law. All right, so your Attorney General is General Keith Ellison. If you were unaware, you may share that in common with some people in Minnesota, but he is the Chief Law Enforcement Officer in the state. He's an elected official and is a constitutional officer in the state. The mission of the AG is to help Minnesotans afford their lives and live with dignity, safety, and respect, which goes right in line with the new Privacy Act. So the Attorney General's office is separated into a number of divisions. Each division has a team within it of assistant attorneys general. That's me and Caitlin, for example, investigators and paralegals. We enforce specifically the Consumer Protection Division that we're a part of enforces various consumer protection statutes. Our bread and butter, generally speaking, is the CFA. It's the Prevention of Consumer Fraud Act, the Uniform Deceptive Trade Practices Act that you might hear me slip and say UDAP, and the False Statements and Advertising Act. There are others. There are a number of consumer protection statutes that are explicitly mentioned in Section 831. 831 also gives us authority to enforce any law pertaining to unlawful acts in commerce, essentially. But then some statutes specifically give the Attorney General authority to enforce them. This is one of those statutes. The MCPA has grants explicit authority to the AG's office for enforcement. And as I mentioned previously, there's no private right of action here. The Consumer Protection Division and the AG's office writ large can initiate investigations or file lawsuits if we identify and establish a pattern or practice of violation. I've got a question here. Does this law exclude independent insurance agencies as insurance companies? I think you will want to check the wording of the statute for that. It's a pretty specific question that may rise and fall in the exemption language. All right, so how are we preparing for enforcement? We are expanding the privacy enforcement team. So Caitlin and I are currently part of the team. We have a third attorney who is on the team as well, and we are hiring more. The legislature specifically funded this division or this subdivision and is looking to hire additional people to ensure that the law is followed. We have a dedicated privacy website, which has been put into the chat, privacymn.com. And we are able to, I'm sorry.
No, I'm sorry. I think we're just behind a slide.
I think that's right. I'm so
Sorry to
sorry.
interrupt. Go ahead.
So no, we have educational materials for consumers and businesses, which is what we're doing right here. And we're engaging in outreach and training. This is fourth presentation we put on, and we're probably putting on more. And we hope to reach as many businesses in Minnesota as we possibly can. And we already kind of talked about the cure periods. Pass it on.
Thanks, Noah. Okay, just want to leave with a couple of tips and thoughts on how to interact, how we would appreciate interacting with our office if you happen to receive a letter from us or other inquiry. Just so you know, as I mentioned earlier, it is very typical for us to reach out with inquiry letters, regardless of whether or not the law requires that of us. And so you might hear from us in that capacity, or an email or a phone call, or on the more formal side, a civil investigative demand, which is interrogatories and document requests. And so whatever it may be, I strongly recommend engaging with us and being as transparent and forthcoming as possible. When we see companies ignore us altogether or provide evasive answers, it certainly gives us reason to dig in further. And I think it's most helpful, and what we are hoping to do as we engage with companies is to understand from your perspective, learn about your business, learn about the efforts you've made to comply with the act. Usually we're seeking information to satisfy a curiosity or an inquiry. It does not necessarily indicate that there's enforcement action coming, and that's certainly the case with regard to this act. Our number one goal is to champion privacy. We are not trying to tally up enforcement actions. And so we're hoping to hear from businesses that we interact with in these next 6 months and going forward about the efforts that you have made, the decisions you wrestled with, the privacy safeguards that you've enacted since this law. And we look forward to engaging with the business community on that. Certainly not looking for perfection, but rather some good faith efforts. And I think that wraps up our presentation. We very much appreciate the BBB hosting this. We're very glad to be engaged with the BBB and its business partners. We look forward to engaging more with the community as the law comes online. As Noah mentioned, we have launched a website, www.privacymn.com, where you can find even more resources about the law and whether or not kind of digging into some of the questions in the chat as well as other resources. And with that, I think we've answered the questions.
And we did skip a slide.
Oh, okay.
And no, it was totally my fault. And the slide that we skipped was about enforcement, and I just want to kind of revisit it
Thanks.
because it does address some of the questions from the first person who chatted us. So the enforcement in an enforcement action that the AG takes under the statute, we can seek and obtain up to $7,500 per violation. That I don't know if it seems like a lot or a little to you, but under our normal statutes, generally speaking, we're allowed to seek up to $25,000 per violation. So this is technically a reduction per violation. But in reality, if you think about the pattern or practice violations that we're looking at and the fact that generally speaking, one violation here is going to be applied across a universe of 100,000 plus customers, $7,500 per violation can get very large very quickly. We can also, under our statute, seek reasonable litigation expenses, which includes attorney's fees, includes costs of filings, and includes the cost of our investigation, and can also provide for other remedies. Also provides for other remedies that we can seek by law, like restitution. So, a number of sticks, in addition to the carrot of hoping that providing assistance and understanding the law.
So no, there's a question in the chat that asks about a requirement under Minnesota DOLI requiring picture and videos for virtual inspections. Any thoughts on how this will impact, or is it a requirement, how this will be impacted by the new law?
So DOLI, for everyone's reference, is the Department of Labor and Industry. And I think I interpret this question to be asking if that Dolly is asking for pictures and videos so that it can perform virtual inspections of your business rather than have inspections done by what I assume you're asking are Dolly inspectors. How will the MCDPA impact this? So Dolly as a government agency is going to be exempt from the requirements of the MCDPA. I think that answers this question. If it doesn't, please feel free to rephrase it. So we've got another question in here. It looks like that that they are a small business by the SBA standards. So as long as they're not selling data, are they good to go? Does the law impact them?
So I think under as I understand the question, if you are a small business as defined by the SBA, you are exempt from the law with the exception that you may not sell sensitive data without consumers' consent. So it sounds like that's probably the case. I will just flag that I would keep a close eye on the development of this law. Representative Elkins just yesterday was mentioning um, that he may be advocating for changes to the threshold. And so it will be prudent for businesses, even who may not be subject at this moment, to keep an eye on this and or build in some of these processes for future evolution of the law. Anything to add?
No.
We are happy to take other questions if there are any. Give it a minute. Certainly appreciate that. For those of you who are hearing this for the first time, it's incredibly dense and there's quite a lot to take in. So just want to say again that we remain available and we'll be looking forward to engaging as time goes on. So this is definitely not the last time you'll have the chance to get a hold of us and dialogue about the requirements of the law. We will be available going forward.
Yeah, and we were talking before about how to get questions to us about, let's say you're a business that wants to get a little bit more information about the law and you don't have an easy way of reaching into the AG's office. On the privacymn.com site, which it's a .com site, but it does redirect you to a state website, like an mn.gov website or mn.us. There's a complaint form on there that's specific to privacy issues. It's mostly set up in the context of a consumer complaining about not being able to exercise their rights. But I would encourage you to fill out a complaint form as a business if you have questions about the law and would like to ask, for ask questions about how the law might apply to you. This is all with the caveat that we can't give you legal advice and we're not your attorneys. And so we're never going to be able to give you specific advice for your specific situation. But we may be able to set up a call to talk about the general requirements of the law to help explain things to your entity on a case-by-case basis. That complaint form is styled again in the context of a consumer complaint, but the complaint form is going to get to us. It's going to get to the privacy team, and we're going to put eyes on it. And so, if you explain what you want in that form, we'll be able to reach out and kind of address questions if you have them. Well, I just rambled for a good 2 minutes, just thinking maybe there'd be another question. Oh, we got another one. All right. So this, I think, goes with kind of dovetails with the question that we had previously about a criminal statute that I didn't really address. Can victims of exposure of sensitive data, of non-consensual imagery, use this law or the AG's office to get help? So it's a, it's not exactly a relevant law for that. And so why do I say that? So 617 is a criminal chapter. I'll just put it out there. It's a criminal, there's a bunch of criminal laws in it. I don't know extensively the law that you're referring to. I can kind of infer based on the title that you gave it of non-consensual sharing of imagery and sexual explicit images. Again, and this is more commonly known, I think, as the revenge porn law. And mostly we're looking at entities that are large. And generally speaking, those criminal statutes are not going to be applying to a company that is releasing 100,000 non-consensual images. Maybe it would. And in that case, then both laws would likely apply. So can victims of it of non-consensual imagery use this law to get help? Maybe in the sense that the data that consists, the images of somebody that are held by an entity that is subject to the law, if somebody asks them to delete it or get rid of them, and that entity is subject to the law and ignores those requests, then theoretically that person has, exercised their rights under the law and been ignored, and they could complain to the AG's office, and we would take a look at the potentially violating company to see if the law applied and what, if anything, we could do about it. I will never tell someone to not complain to the AG's office. It's better to put it in front of us and let us see what we can do about it than to dissuade someone from making a bona fide complaint.